Into context, this is what happened on October 6th last week as the Speaker of the National Assembly, that is Moses Wetangula, ruled that Kenya Kwanza has the majority in the National Assembly. And of course, this ended the session in a bit of pandemonium, and it was not so civil or ruly, but somehow order was restored a bit later on. And this is how it played out as packaged put together by Duncan Haimba.
Order, honorable members.
National Assembly's Thursday afternoon sitting abruptly came to an end after Azimio la Umoja One Kenya affiliated members attempted to remove the mess as they protested Speaker Moses Wetangula's ruling that denied Ugunja Member of Parliament Opiyo Wandayi majority leadership position, handing Kenya Kwanza's Kimani Ichung'wah.
Order, honorable members.
In his communication, the Speaker said 14 members elected on 4 parties of Maendeleo Chapchap, UDM, MDG and PA cannot be held at ransom by coalition agreements when they have already stated they are no longer partners.
The members elected this house under the 4 parties have exercised their freedom of association under Article 36 of the Constitution. They have already migrated the Kenya Kwanza Alliance both in writing and in action. The parties are already enjoying the benefits accruing from their membership of the Kenya Kwanza coalition.
Wetangula criticized the Registrar of Political Parties, accusing her of perpetuating dictatorship.
Section 10 of the Political Parties Act 2011 is clear that coalitions are not cast in stone but are an evolving arrangements which can occur both prior to and after election.
Ugunja MP Opiyo Wandayi, who was majority leader designate at least on paper until 5 p.m. when the Speaker relegated him to the minority bench, expressed his disappointment.
I don't agree with it. In line with the rules of natural justice, tenets of democracy, and established jurisprudence, I would wish to give notice that we shall be moving, Mr. Speaker, shall be moving you to review your decision.
Once the Speaker makes a ruling such as the one I have made, is not subject to debate, it is not appealable, and it stands as it is.
Outside the chamber, furious Azimio coalition members condemned the Speaker, terming him a puppet of the executive.
This is the capture of the executive. This is the capture of parliament by the executive. It has begun. It is for the first time a Speaker in his place is removing members of parliament from one party to another party. He has become the registrar of political parties. He is the Speaker of the National Assembly. He is law unto himself.
KANU party, I want to categorically state that Honorable Kamket is not our party leader, neither is he the Secretary General of KANU party, so that he can come to purport to speak on its behalf, to come and say that he is a member or KANU is a member of Kenya Kwanza Alliance. I want to say as a member of KANU party and other members in this parliament that we are in Azimio One Kenya Alliance, and he can only speak for himself, and if he wants to join Kenya Kwanza, he can resign and go for election.
What we have witnessed today is dictatorship by parliament and through the Speaker.
On their part, Kenya Kwanza members of parliament were in jubilation.
It is what it is. I'm sure you have all followed the Speaker's ruling. And as the Kenya Kwanza coalition, we completely identify ourselves with the ruling of the Speaker.
And from that ruling by the Speaker of the National Assembly, Moses Masika Wetangula, once again for the 3rd time, the Raila Odinga-led coalition will be the minority in the National Assembly. Duncan Haimba, NTV, Parliament.
So let's start from there, and we'll open the lines for you to ask the Waheshimiwa's questions from your standpoint. As a Mwananchi, already Opiyo Wandayi has termed himself leader or servant of the people, so he's here to answer your questions. I'll start with Bwana Cherargei. You've heard there the description of the ruling last week on October 6th. This is capture of parliament by executive, Junet said, dictatorship by parliament. This is by Mbadi in reaction to this. What is your stance just to put this to rest, this issue to rest on majority leadership in the National Assembly?
Thank you very much, Mark, and thank you for hosting me alongside my brother, a servant of the people, Opio and I.
Very good.
Mine is just what happened in the National Assembly is, as per the law, when you listen to the ruling of the Speaker, Moses Wetangula, it is very clear. As you are aware, the standing orders of the National Assembly, to be precise, standing order number 18, talks about the appointment of majority leader and minority leader. And it says it's either a political party with the largest membership or a coalition of political parties that will form the majority side. And the second, in the similar manner, is the minority side. This is in line with Article, I think, 108 of Constitution 2010 of Kenya, where under the Constitution, it creates the position of minority and majority side. When you look at standing order number 22 of the Senate standing orders, the similar applies, mutatis mutandis, or in similar manner, where also there is designation or the party with the largest membership in the Senate or coalition of political parties with the large membership forms the majority, and the second in terms of numbers forms the minority side. And I think what happens is that many people don't understand the dynamics. One is that there is no day that any arm of government can direct each other. I've heard people talking about registrar of political parties or office of registrar of political parties under the Political Parties Amendment Act of 2021, trying to insinuate that the registrar of political parties should dictate on how political parties should be in the National Assembly or the Senate.
Right.
This matter came to the Senate, it also went to the National Assembly. But you have to appreciate one factor, that the principle and doctrine of separation of powers is there is no day a court of law can order parliament or parliament can order executive, because it's part of doctrine of separation of powers. Number two is, when you look at the ruling of the Speaker and look at the Constitution, you have to appreciate one fact, that the Political Parties Act is a legislation. So the Constitution is supreme. And that is why you heard the Speaker talking about Article 36 and Article 37 and 38 on political parties' rights, and also freedom of association. So it supersedes or superimposes the Political Parties Amendment Act. Number three, when my brothers, including Opio and I then, and they used to enjoy government and the largesse of government in a former mongrel government, I don't know what it will call, handshake or something like that, when they were pushing amendment of Section 2 of Political Parties Amendment in 2021, some of us were in record that this thing will come to haunt you. Because in that amendment, it created coalition political party. In Parliament, there is no coalition called, either in the National Assembly, in the Senate, called Azimio One Kenya Alliance, political party. There is no Kenya Kwanza political party. Because they amended Section 2 to say there is a coalition political party. So it meant when you go to the National Assembly, you will not get MPs of Kenya Kwanza or Azimio One Kenya. You will get ODM, Wiper, UDA, Ford Kenya, ANC, and the rest. When you come to the Senate, it applies the same. The only person who vied under coalition political party is Raila Odinga and Martha Karua, and they added on the ballot paper called Azimio One Kenya Alliance.
All right.
So in all instances, when you look at that thinking that Senator Moses Masika Wetangula, the Speaker of the National Assembly, he made, and therefore, as I conclude, my brothers Opio and I and the rest had their right to not agree with the decision of the Speaker and criticize. It is a principle of open democracy.
All right. So the capture of Parliament by executive description is
It does
misplaced.
not exist because there is nowhere. I don't see.
Okay.
Those are political expediency statements.
In your submission, Bwana Opiyo Wandayi has gone through the Daily Nation and is now to the next paper. So I guess you've been talking for quite a while.
Yes.
Bwana Opiyo Wandayi, the decision, of course, is something you don't agree with, but the Speaker says it is not appealable. It stands. Does this mean you will continue as minority leader, or is there any action that you are going to take, or this is water under the bridge?
Mark, thank you. At least by taking the much time you took, Senator Cherargei has enabled me to go through the newspapers. Yeah, I'm now a little bit more informed
Yes.
than when I came. That aside, Mark, a number of issues have been raised. I wouldn't ordinarily want to go back to the happenings in the National Assembly last week, prior to and after the ruling by the Speaker, for two reasons. One is that we have canvassed those issues for long enough,
Okay.
both sides. But more importantly, I am aware that the Azimio la Umoja coalition party is considering seeking legal redress.
Okay.
Yes, on the ruling by the Speaker of the National Assembly on the matter of the majority and the minority coalition parties. And therefore, I wouldn't want to delve so much into the merits or demerits. But having said that, it's important for me to put some issues in context. It's very important now that I'm here.
Yes.
Yeah.
Go ahead.
With you and before the public.
Yes.
A number of untruths have been said by my colleague, who I highly respect, Senator Cherargei. And let me start from where he left. You know, Mark, this country is governed by the rule of law. And the Constitution is the supreme law of the land. The Constitution itself sets out how statutes or ordinary laws are to be enacted, okay, amended, or repealed, for that matter. Yeah, and therefore, it is not right, not proper indeed, for one to rubbish outrightly a statute law which is in existence, such as the Political Parties Act, in the manner both the Speaker and now my friend here have attempted to do. As we speak, the Political Parties Act, as indeed amended last time in February this year, is still law. No court of law has declared it unconstitutional. Yes. And therefore we have to live with it. And it provides very clearly, yes, very clearly how political parties are to be formed and managed. Okay, it is the same law that has created, okay, a situation where a political party can function both as a political party and as a coalition of political parties. That is the law. Nobody has challenged it and succeeded, yes, in the court of law as is required. Secondly, a lot has been said about the right to the freedom of association as provided under Article 36 of the Constitution. I also had talk about freedom of political choices, the right to make political choices as enshrined under Article 38 of the Constitution. Fair enough. We all enjoy those rights.
Yes.
And we must protect them jealously. You know, there are rights that we attained after a very long struggle, a struggle that left many people maimed.
Yes.
Others lost their lives, you know.
But they come with consequences.
And others were jailed for it, like my party leader, yes, was jailed for a period of not less than 9 years fighting for these rights that are now enshrined in the Constitution of Kenya 2010.
Okay.
But let me tell you, and this is the problem with reading a constitution selectively. Yeah, I always say that when you want to read a constitution, you must have a holistic reading of the constitution for you to come up with a proper interpretation. Okay? My brother here is a lawyer, and he should know this. Yes. That those freedoms and rights under the Bill of Rights, that is chapter 4 of the Constitution, have a caveat. Okay? There are situations where they can be limited, and that is expressly provided for under Article 24 of the Constitution. And why do I say this? Political parties that came together out of their own volition prior to the August 9 elections and formed the Azimio la Umoja coalition, about 26 of them, my party ODM being one of them, did so voluntarily in exercise of their right of association and right of political choices under those articles.
Those who left would argue they've left voluntarily as
well. Now, by signing to the Azimio coalition, those parties, again, without any form of duress or coercion, declared by themselves that having joined the Azimio la Umoja coalition, they would only be able to leave that coalition after 3 months after the election of 9th of August. That's the earliest they could leave, or could start the process of leaving, was 3 months after the 9th August. Okay? Now, when you turn around and start saying that you are being forced to stay in a relationship that you are unhappy with, and yet it is you who agreed to that relationship, together with these terms. Now, who is fooling who? Okay? These same parties, let me also make it clear, because the public needs to know this. A number of them have tried to extricate themselves from the coalition agreement, the Azimio coalition agreement. I think that party of Mutua is called what? It's called Chap Chap.
Yes.
Chap Chap has tried. Another one has also tried, Think Pa of Speaker Kingi. They have gone to the political parties dispute tribunal, which is a requirement of the law, that if you have issued a coalition or a political party, the first port of call is the political parties dispute tribunal. That tribunal has declined to grant them their prayers, to be allowed to leave the Azimio coalition.
Right.
They have gone, some of them have gone to the court, High Court. The courts have refused to allow them to live in the manner they are attempting to live, that they must go back and abide by the coalition agreement before they can formally leave the coalition. Now, what was happening in Parliament, unfortunately, in the National Assembly, is that people were attempting to invite the Speaker to grant what the courts have declined. People were going around the political parties dispute tribunal, which is a quasi-judicial body, you know, and the High Court have both declined to allow these parties to exist as a mini coalition in the manner they are attempting to do. And yet they go to the Speaker, asking the Speaker to declare that they can leave. So the Speaker, in making his ruling, of course, made a very serious error in law.
So you're saying Moses Wetangula, in effect, with his ruling, endorsed an illegality?
Totally.
All right.
Totally.
I'll give an opportunity to Chirarge to respond to some of the issues that you've raised. Yes.
Watch this space.
Because you say Azimio plan to seek recourse.
But let me say this, even as he picks it up from there. We have decided as a matter of strategy, as a coalition, that even as the coalition party proceeds to court to seek the court's opinion on this matter, we as the Azimio coalition parliamentarians will continue to play our role in Parliament.
Okay.
We shall take up our roles and keep the executive in check which is our primary duty.
All right. Bonacharage, please respond to the
Let
issues
me
raised.
pick it from where my brother has left the servant of the people. One is that I agree with him that Article 94 and 96 provides for the roles of the National Assembly and the Senate, including keeping the executive in check.
Yes.
Number two, it would be a fallacy to mislead the public and the esteemed viewers to say that the judicial processes have been exhausted. The only time my brother can say with finality that Maendeleo Chap and Pamoja Africa Alliance, the PA, that have moved to court as been defeated, or they have not gotten orders of moving out of Azimio One Kenya Alliance, is when the tail end and the highest office or the apex is the Supreme Court. So that would now, we can come back and say the courts have declined, because you can't, if you have not existed all your appeal mechanisms.
Yes.
Number two is talking about coalition political party. Him and me know that the only people who vied under coalition political party was Raila Odinga, even in their ballot paper. But him, he vied under ODM, and he was elected in ODM. When you go to register of political parties, he is in a coalition called Azimio One Kenya Alliance, but he is in ODM, just the way I'm in UDA,
yes,
but in a Kenya Kwanza coalition. But that one is not a coalition political party. So there should be a distinction between a political party, which is ODM, and coalition political party, which was registered only. And there is no one that there is no member of coalition political party called Kenya Kwanza or Azimio One Kenya Alliance. When you talk about the reading of the Constitution is read in whole. And he knows very well that even as you interpret the Constitution, let us allow the courts to take their time. And that is why I said, when you look at the supremacy of the Constitution, the fact that freedom of association was quoted by Senator Moses Wetangula,
yes,
is because he knows that the Constitution is supreme, beyond and above an ordinary legislation of Parliament. And that is why they talk about even cultural and traditions and repugnancy of customary law. And therefore, in all intents and purposes, when you look at the National Assembly and the Senate, the Azimio, or you would call them, for purposes of this conversation, Azimio or ODM or WIPA, forms the minority, both in the National and in the Senate. And they have agreed with that. Because, in fact, my brother Opio and I, unless he is new in Jerusalem, and you and everybody else who is watching this, most of these people, including Maendeleo Chap, Pamoja Alliance Africa, yes, UDM, they have even on record, and even Senator Ali Roba of Mandera was on the floor of the Senate, and it is even in the answer, that he said most of them were being coerced to be in the coalition. This was not a coalition of the willing. It
wasn't voluntary.
It was not voluntarily, as my brother wants to assess. Unless where my brother was, he might have been misled that this was a coalition of the willing. Yet most of these people were being twisted, they were being emasculated to join Azimio One Kenya Alliance. And you know, most of them complained, even during campaign. There was a serious fight within Azimio political parties in terms of campaigning, in terms of even resources, even the issues of non-payment of agents, among other things. But I think that is water under the bridge. But the bottom line is that we should allow Kenyans to make the political choices.
Okay.
And I allowed the wisdom that Speaker Wetangula did, because in as much as the other processes are ongoing, and by the way, Azimio and Kenya Alliance have all the right to go to court. But they must be made aware that in the previous parliament, the nominee of AG, the former speaker, J.B. Muturi, even in one of his rulings, when he was talking about the whipping of members, specifically the whipping of then by NASA of a member of Kenya, David Ochieng, where he ruled that there is no other arm of government that can direct the other. Cite that there is no day that political parties registrar can direct parliament and tell them, yes, this is how it looks like. Right. It only informs in any decision that convenes and in terms of consideration.
As you respond, Bwana Opio, you say you will continue as you seek other avenues of appeal to this decision, if we call it that, that you will continue with your functions to hold the executive to account. But it has already this decision by the Speaker to rule that, you know, the majority is with the Kenya Kwanza side, and you have accepted to be part of the House Business Committee as a minority leader. Aren't you then endorsing something that you already call an illegality? And a layman would ask, why not sit it out? If you disagree with this, you've already agreed to be part of the House Business Committee as minority leader.
You know, Mark, before I answer you, I think we need to move this debate forward.
Yes.
And when my colleague was speaking, I was wondering whether I am communicating or not. You know, the issues here are very clear. They are extremely clear. It is what the law says, okay? And we are saying that the Speaker cannot abrogate himself powers, okay, that are the exclusive mandate or province of the judiciary. Under Article 165 of the Constitution, my brother here should know, it's only the High Court that can declare whether a law is unconstitutional or not. In fact, it's only the High Court that can interpret a constitution. So that is not the work of the Speaker. And I, of course, have said I don't want to dwell much on that.
Yes.
Yeah. Secondly, Mark, you know, if we don't get a court interpretation on this matter, we shall have set a very dangerous precedent. Mm-hmm. Yes. Because by that one ruling, the Speaker has made it basically useless for people to come together as coalition. Okay? Because if a Speaker can undo or make a coalition, yes, by basically dint of a ruling, then why bother? Okay. Why bother? So that has to be set, has been made clear, and the only institution that can bring that clarity is the judiciary. Right. Okay. Yeah. But now, I have said, okay, that we have made a strategic decision. Right. Yeah, mark my words here. The poetic word here is strategic decision. Yes. To take up our roles in the National Assembly. And remember, Mark, majority or minority, the role of the National Assembly specifically, if I leave out the Senate, which is the abode of my brother here, is to oversight the executive. In fact, not just the executive, oversight other arms of government, including the judiciary. Okay? Apart from the work of legislation and representation of the people. Okay? So that's something we have to do. Yes. Okay? And therefore, by taking up our positions in the House Business Committee and what have you, we are simply executing our constitutional mandate. Okay. Okay? Regardless of what you call us minority, call us majority. Yeah. That is not important. Right. That the court will address. Really. And there's nothing that jeopardizes the court's possible decision on this matter. Yes. Yes. And the capture of parliament by executive for you does not warrant or at least say that your cause to hold the executive to account is hopeless now. You know, we have been in this situation before. Yes, we are not really an entirely new territory. We have seen all this before. And that's why we must remain vigilant as Kenyans. Yes. We must remain extremely vigilant to avoid a situation where we cloud back on the gains we have made as a country over the years, okay? To avoid the country regressing into the dark old days where Parliament was an appendage of the executive, yes. Okay? That's why we have chosen, yes, to ensure that we stick to our mandate in Parliament and safeguard the integrity and credibility of Parliament as an institution. Okay. Yes, against possible encroachment or manipulation by the executive. You know, every executive, even if it were you, Mark, if you became president of this country today, I'm sure you would want a parliament which is easy to deal with, okay? Which is compliant, okay? And that is what every executive or president would want to do. So it's upon the parliamentarians, including the speakers, yes, to stand firm and guard against that kind of eventuality. Yes. That's what I'm saying in short. All hope is not lost to hold the account. There can be no hope that is lost. Okay. Because we are here in defense of the people. Remember, as Azimio, Moja Coalition, we represent more than half of the country. I'm sure you know that. Yes. Yes. So we cannot let our people down, our supporters, and in fact, all other Kenyans.
entire Kenya.
All other Kenyans, really.
Yes.
Yes. Yes, because we speak for the people.
All right.
Yes.